Welcome to our recorded presentation of Massachusetts House Bill 1003. The bill was written by the Wendell State Forest Alliance and is being shepherded through the 21 to 22 legislative session. We have created this recording to share the story and importance of this bill as we garner sponsorship from our state legislators and seek support from fellow concerned residents and organizations. Thank you for your interest. Our contact information will be provided at the end of this presentation.
House Bill 1003, an act to ensure accountability and public rights regarding commercial tree harvesting on Commonwealth-owned lands.
The Wendell State Forest Alliance formed in 2018. We are a broad cross-section of our communities. We are scientists, plumbers, farmers, social workers, writers, artists, builders, medical professionals, and many others. We are from communities in Franklin, Hampshire, Hampden, and Berkshire counties, and from Boston as well. We came together as a group of concerned citizens to stop the commercial logging in Wendell State Forest of 100-year-old oak trees slated for cutting by the Department of Conservation and Recreation, DCR. Our efforts were driven by the most current scientific knowledge, citing intact forests as necessary to mitigating the climate emergency. We know that forests store and sequester carbon from our atmosphere, clean our waters, and provide for the biodiversity that is necessary to our planet's and thus humankind's own survival. The social benefits of intact forests are enormous. We engage in numerous activities, including participating in public comment periods, meeting with the Department of Conservation and Recreation, the Executive Office of Energy and Environmental Affairs, EEA, and the Attorney General's Office, public education, public records requests, civil disobedience, and filing a lawsuit in Franklin Superior Court. Though we were arrested many times trying to save our beloved forest, we acted not only as defendants, but also as plaintiffs seeking an injunction in Superior Court. We sued because after our comments were ignored, we were told that the public has no right to appeal public land use decisions, even those that would harm the environment and reduce our climate resiliency. The lawsuit was our response to DCR's failure to consider the most up-to-date science and failure to acknowledge and respond to our citizen right to participate in choices that affect our public lands. We cited numerous statutory and regulatory violations, but still our case was never heard on the merits. After filing hundreds of pages and more than a year of hearings, in September 2020, Justice Richard J. Carey dismissed the lawsuit, finding that 1, there is no legislative avenue allowing citizens to intervene, and 2, the issues raised required new or amended legislation. Justice Carey decided that we could not hold DCR accountable to the Massachusetts Environmental Policy Act, MEPA, because the legislature did not see fit to provide a mechanism for private individuals to seek enforcement. The Wendell State Forest Alliance has submitted House Bill 1003 to address the legislative deficiencies identified in these findings.
Section 1, Expanded Forest Policy Goals. It is hereby declared that forest management policy on Commonwealth-owned lands shall incorporate the manifold benefits to public welfare that accrue from the protection of the living diversity of forest-dependent organisms and from the contribution forests provide in the form of natural carbon sequestration, which is of critical importance in confronting the global threat of climate degradation.
When considering public lands, we hold that the public is both the landowner and the beneficiary of decisions. We hold that the agencies who are charged with managing these lands work for us, and that they are failing in their responsibilities to the public welfare in many critical ways that have already been addressed by legislation designed to protect the environment and minimize climate disruption, but which are missing mechanisms to ensure compliance with these existing laws. This bill aims to fill in the gaps in current legislation so that everyone, including state agencies, can be held accountable.
Section 2, analysis and disclosure of environmental and climate impacts. All commercial tree harvesting and associated activities on Commonwealth-owned lands and their foreseeable climate impacts shall be subject to sections 61, 62, and 62B of the Massachusetts Environmental Policy Act, Chapter 30, and shall be the responsibility of the agency proposing such action.
Before, during, and after the logging of Wendell State Forest, our concerns were brought to Secretary Thea Hardees of the EEA, who oversees both DCR and the Division of Fisheries and Wildlife, or DFW, the main agencies selling off our forests. Our issues were dismissed summarily. At this point, with the logging well underway, we were stuck and had no recourse but to stand before the machines while scrambling to put together our lawsuit. All project impacts on the ecosystem and on carbon stocks must be analyzed and disclosed per MEPA. Carbon emissions of the scale caused by industrial logging of our public forests we see as being subject to accounting per the Global Warming Solutions Act of 2008. However, both DCR and DFW claim complete exemption from these laws. Our bill reinforces these responsibilities and creates the ability for any concerned member of the community to ensure they are met before the harm is done.
In addition, said harvesting and associated activities shall be considered a significant greenhouse gas emission source and therefore subject to all relevant requirements of the Global Warming Solutions Act, Chapter 21N. Forest management plans shall be evaluated in comparison to passive management and shall incorporate longer-term impacts and the social value of natural carbon sequestration.
Since we filed our bill, some legislative progress has been made to require forest carbon accounting and protection with the passage of S9 into law as Chapter 8. This means that our legislators are paying attention. It also means that we need H.1003 more than ever to ensure that the forest-related parts of this important new legislation are implemented properly and promptly. This is necessary because Massachusetts has been weak on implementation of new and not so new environmental and climate laws. Multiple secretaries of the EEA have failed to require the accounting of forest carbon loss, so neither DCR nor DFW have been counting their carbon impacts. H.1003 requires that carbon accounting of logging activity be compared to the alternative of not cutting. We know from recent peer-reviewed science that so-called passive management retains between 39 and 118% more above ground carbon than various management approaches that involve logging. In fact, the difference is even greater when below ground carbon is counted as well. The Wendell State Forest Alliance has learned much from scientists such as Bill Muma, lead author of several IPCC reports about the mitigation of global warming. It is he who, in seeking a term to describe what needs to be done to save our forests, coined the term proforestation.
He wrote, in sum, proforestation provides the most effective solution to dual global crises, climate change and biodiversity loss. Section 3, commercial activity, finding of essential. All commercial tree harvesting and associated activities on Commonwealth-owned lands shall be subject to Section 2B of Chapter 132A and shall be considered commercial activity. Any such proposed activity shall be analyzed to ensure that it is essential for the quiet enjoyment of the facilities by the people, and a subsequent finding shall be issued by incorporation into any decision regarding said proposal.
When I look at this picture, I remember the day I took it. My Wendell brother Jim and I had come to witness the devastation of our beloved forest. We walked for hours, and this is all we saw. 47 cuts like this, the stumps still dying, the drying sun beating down on habitat that had been so vital, and all the dead limbs which to this day still lie where they fell. This is a picture of what was for decades a popular favorite area for recreation and meditation in nature. Wendell State Forest was a healthy and resilient forest, but was targeted for harvest because of its many valuable mature oaks. In court, the state attorney claimed that logging was necessary because there were sick trees that would fall and hurt someone, and offered other unfounded justifications. Our local biologists observed that this was a sound and healthy forest, doing just fine without human intervention. Clearly, what happened here was not essential for the quiet enjoyment of this forest. This section of our bill would put the burden on the planning agency to account for the essentiality of any project they propose.
Our House Bill 1003 references Chapter 132A, an already existing law. We would like to read Section 2B, Nature of Use of Acquired Lands. It is hereby declared to be the policy of the Commonwealth that all such sites acquired or developed by the Commissioner shall, insofar as practicable, be preserved in their natural state, that they shall be, insofar as possible, collectively self-supporting, and that no commercial activities except those essential for the quiet enjoyment of the facilities by the people shall be permitted.
We think that the plain language of this existing law should already protect all public lands from commercial logging. Unfortunately, DCR and DFW have been allowed to ignore it and go about business as usual. Many of us are well versed in the greenwashing justifications given for the extractive practices that are a lose-lose for us, the people. We are also familiar with the peer-reviewed science which DCR habitually contradicts.
Section 4, Public Right to Participate, Incorporation of Public Comments. Any person or persons domiciled in the Commonwealth shall have the right to participate in every stage of the planning for all commercial tree harvesting projects on Commonwealth-owned lands. Public comments to proposed projects shall be substantially incorporated as reasonable.
Although many concerns and objections were submitted during the public comment period, they were not incorporated into the forest cutting plan to log 88 acres of century-old oak trees on Brook Road in Wendell State Forest. It is a Commonwealth right that we have a voice in public land use decisions. Any individual who cares enough to participate should be taken seriously. However, historically, public comments which challenged projects' legitimacy of purpose have been received and filed away without consideration. This section would require the planning agency to respond substantively to public input.
Section 5, Notice of Decision. Any decision to conduct commercial tree harvesting on Commonwealth-owned lands shall be made formal and published in the Environmental Monitor of the Massachusetts Environmental Policy Act office. All persons who have participated in any part of the planning process leading up to said decision shall also be individually notified of the decision and have the right to appeal as provided in Section 6.
In order to facilitate substantial public involvement, agencies must be mandated to give timely notice of their projects. Currently, this requirement does not exist, resulting in the disempowerment of the public to effect timely intervention. In fact, one reason that our case was dismissed was because our injunction was filed after logging had begun. And this was because we were given no notice of the issuance of a cutting permit. This section of our bill lays out a simple, effective process for publication and notice of public land use decisions.
Section 6, Right to Administrative Appeal, Individual and Collective Appeal Process. If aggrieved by a decision to conduct commercial tree harvesting on Commonwealth-owned lands, any person who has demonstrated engagement in any part of the scoping or planning process shall have the right to appeal as an individual in accordance with Section 14 of the State Administrative Procedure Act. Individual appeals must be initiated within 30 days of notice of the decision.
The action pictured here is not the type of intervention we are looking for, if it can be helped. We are talking about working within the system through administrative appeal, which is a formal objection made directly to the agency regarding their decision.
In addition, any group of 10 or more persons domiciled within the Commonwealth may join together, and in so doing shall have standing for the purpose of appeal. Group appeals must be initiated within 30 days of publication of the decision in the Environmental Monitor. The appeal process shall be conducted pursuant to Chapter 30A and in accordance with the standard adjudicatory rules of practice and procedure, unless other specific procedures are established by promulgation of regulations as described in Section 8.
Inexplicably, the public has yet to be granted the right to appeal public land use decisions. This section simply provides that right. It establishes automatic standing for individuals who have already engaged in the planning process, and furthermore, allows any other concerned residents to get involved at this stage once they meet the requirement to amass a group of 10 persons.
Section 7, Standing for Civil Action. Upon exhaustion of the administrative remedies provided in Sections 4 and 6, any appellant may combine with any other 9 or more persons domiciled in the Commonwealth to file a civil action in the Superior Court for the county of the project site.
This section makes clear that 10 or more members of the public together have standing to initiate legal action regarding a specific project. It would prevent our disqualification in court based on having no standing, as the judge ruled in our case. The notion of such intervention is not a new one. Already there is Chapter 214, Section 7A, which allows 10 residents to intervene in court to prevent damage to the environment. But that law contains other requirements which allowed for a loophole in our case, since the court refused to rule on whether we'd met these. H.1003 guarantees specifically our right to take legal action in regard to commercial logging of our public lands.
Section 8, Requirement to promulgate regulations. The Secretary of the Office of Energy and Environmental Affairs or her agent shall promulgate reasonable regulations in accordance with the State Administrative Procedure Act, Chapter 30A, for the implementation of Sections 1 through 7.
Regulations must be promulgated for the implementation of this law. The secretary who oversees both land management agencies shall be the responsible party. The process of establishing regulations will allow for public input according to existing laws.
Commercial logging on our state lands profits only private companies. Every year, the state loses millions on DCR's management forestry division as it sells off our trees, despite our multifaceted and constant objections. Most importantly, we are in multiple crises of climate, environmental, and biodiversity emergencies. This bill ensures that the public is heard. Protecting the public's interest in our forests is essential and a primary responsibility of our government. The people must be assured legal ways to make our voices heard within the system. More and more of us are showing up every day to protect our forests. We feel an urgency to remedy the issues Justice Carey identified as the Commonwealth continues to plan and contract commercial logging in state forests and on other public lands throughout the Commonwealth. Please support House Bill 1003 in all the ways you have in your hands.
To learn all the ways you can help, visit our website, wendellforest.org, or reach out to us at wendellstateforest@gmail.com. We would very much appreciate the opportunity to engage with you and would be glad to offer a live presentation of this material to your group or legislator. Thank you for your time and consideration.